Welcome everybody to Sotheby's Institute of Art and this program entitled Is the Writing on the Wall? 5Pointz and Street Artists' Rights. I'm Judith Prouda and I am faculty of art law at Sotheby's Institute of Art and a moderator in this evening's program. I'm honored to have my panelists this evening. In alphabetical order, Jonathan Cohen, AKA Mears One, founder of 5Pointz and 5Pointz Creates. Can you hear this? Is it okay? Marie-Cécile Flageol, co-founder of 5Pointz and 5Pointz Creates and curator of the Museum of Street Art. To my immediate right, Angelo Madrigal, director of contemporary art at Doyle. Renee Vara, founder and CEO of Vara Art, and Stephen Wagner, partner at Wagner Burko. I will begin by framing the discussion with a short introduction on 5Pointz, the case, and then begin with our panelists in informal conversation. Since the case is presently on appeal before the Second Circuit, the panel will not be addressing specific issues with respect to the litigation. There will be time for Q&A, and of course you're all invited to reception immediately following the program. If you're like me, you may have taken the number 7 Flushing line that wends its way through Queens on an elevated platform. And if you took this train before November 19th, 2013, you rode by a graffiti-covered, abandoned water meter factory known as 5Pointz. This became the focus of a years-long controversy, a 3-week trial that ended on November 7th, 2017, and a ruling on February 12th, 2018, and now an appeal. This highly significant case will surely set a precedent for street artists' rights. First, a little background about the case and a discussion of a complex and rarely litigated federal law, the Visual Artists' Rights Act, VARA. For well over a decade, aerosol artists, led by curator Maris One, were permitted to paint the facade of a derelict factory complex on Long Island City, transforming it into the world-famous 5Pointz, aka Institute of Higher Bernin, or 5Pointz Aerosol Art Center. The property owner, Jerry Wolkoff, had purchased the 200,000 square foot industrial complex in 1971, with the idea that he would eventually develop the property. The artists were aware that the building would one day be torn down. The artists and Wolkoff did not sign a contract. In 2010, the neighborhood started becoming very valuable. And Wolkoff decided that it was time to develop the property and into high-rise residential towers. When plans emerged that the property was going to be developed to residential project, the New York City Landmarks Commission denied protection. A group of artists, including Mears, the named plaintiff in the cases, filed suit on October 10th, 2013, seeking injunctive relief and alleging that the proposed destruction of the art would amount to a violation of the Visual Artists' Rights Act. The Visual Artists' Rights Act was an amendment to the copyright law, the Copyright Act of 1976. And it protects the right of integrity of artists. The Visual Artists' Rights Act, Part B, states that the visual artists have the right to prevent any intentional distortion, mutilation, or other modification of that work which would be prejudicial to his or her honor or reputation, and any intentional distortion, mutilation, or modification of that work is a violation of that right, and to prevent any destruction of a work of recognized stature, and any intentional or grossly negligent destruction of that work is a violation of that right. The statute does not define what is recognized stature. So what is recognized stature? That is left to the courts to determine. And courts usually require expert testimony to prove that the artwork, that it has stature, that is perceived as meritorious, and that the stature is recognized by experts, other members of the art world, and or some cross-section of society. Eventually, the building was painted over, and I think that you may have slides of that. On the eve of the preliminary injunction in hearing in November 19th, 2013, most of the art was whitewashed and over without any notification whatsoever to the artists. Wolkoff testified in court in a deposition that he hired a crew of painters to begin covering the artwork with white paint and black and blue paint. The district court at that time ultimately declined to grant a preliminary injunction because it was not yet ready at that point in the case to find that street art was eligible for Vara protection. While the court was sympathetic to the artists, it was not yet ready to make that decision. The court noted that the issue of recognized stature, which was not yet defined, it was not defined as a term in the Vara statute, would be best determined when the case was prepared for trial. In a later proceeding, the plaintiff artists alleged that the defendant failed to give them the 90-day notice requirement under the law to remove their work. So in 2017, the court allowed the plaintiff artists to go to trial, finding that the artists had demonstrated they were harmed by the building's demolition under the Visual Artists' Rights Act. In particular, the court found that the question of recognized stature under Vara was clearly a factual one that would be best determined at trial, and that would be necessary to assess the expert's report and testimony at trial. And we are very fortunate to have two of the expert witnesses who testified at trial this evening, Renee Vara and Angela Madrigal. The case went before a jury for 3 weeks in 2017, October, November 2017, and the plaintiffs ultimately decided that the verdict of the jury would be a recommendation to the judge, and that the judge would make the final ruling. The jury verdict was decided on November 7th, 2018, and the jury found that the defendants violated the law by failing to give the artist the 90-day notice, and the judge would decide all the issues, including assessing damages. The jury decided that the plaintiffs would be awarded over $545,000 in actual damages and over $651,000 in statutory damages. The final judgment came in November, in February 2018. A 100-page ruling by the same judge, Judge Block, that had been presiding over the case the entire time. And the judge stated that given the abject nature of Wolkoff's willful conduct, the court awards the maximum statutory damages, and that is $150,000 per violation under Vara for each of the 45 works of art wrongfully and willfully destroyed. Regarding willfulness, the judge had very stern language and said Wolkoff knew from the moment the lawsuit was initiated that the artists were pressing their Vara claims. Wolkoff's conduct was an act of pure pique and revenge for the nerve of the plaintiffs to sue, to attempt to prevent the destruction of their art. This was the epitome of willfulness. The judge went even further than the jury, and the judge ordered Wolkoff to pay a total of $6.75 million in statutory damages to 21 artists. If not for Wolkoff's insolence, these damages would not have been assessed. So now I would like to turn this over to the panel, and I have some questions that I will start to start the conversation. Thank you. So beginning with Renee. Renee, you were one of the key experts on behalf of the plaintiffs. How did you prepare for trial, and what was your expert testimony methodology, and what was involved in proving recognized stature?
The difficulty, and there is a lot of challenges here. One of the challenges is that the 5Pointz developed organically, and so much of the history, as we know it, rests in oral history. And it's part of Vara, actually, to offer a kind of protective element to it, in that contemporary art, when it's contemporary, is not necessarily historical. And so researching it is not like, a typical art history exercise where you just go to, an art history index and you look up the name of the artist and the title of the artwork and you look at scholarly opinions. So that was one challenge. The other challenge was in gathering the documentation for the case, which was very, very dispersed because many of the artists are international. And the third element was that there's no real roadmap at the time that I went to trial in terms of how do you prove recognized stature. I'm a certified appraiser, and it's pretty clear when you deal with issues of authenticity or value. There's a bit of a codified methodology. So that was the challenges I was faced with, and also we didn't have a tremendous amount of time. So what I looked to was Carter versus Helmsley Spear, which is a case which Judith can expand upon, that left a little bit of a roadmap in terms of how the courts may consider an acceptable methodology. And one is that art had to be of merit, and two, that it had to be recognized stature. What recognized stature is actually a relatively open kind of dialogue amongst the legal communities. And certainly in the art world, I can attest to it's not something we talk about every day, like merit and recognized stature. These are not like, what we're talking about in the art world if you work in the art market or studying it. So I looked, the second point I looked to was really another case that very few people in the media talked to, but actually it was a really incredible and landmark situation. His name was Kent Twitchell, and he did a large-scale mural in California on a U.S. government building. And he ended up settling his case, but his case was settled for $1.1 million in 2006. So he didn't go to trial, but there was a few keys and nuggets in there as to how one might look at recognized stature. So I just basically, boiled it down. So I looked at each and every artwork, and it's very important, and why we decided to show images of the actual artworks that were under discussion is because that gets glossed over a lot. There's lots of discussion in the media about the community, the site, both Mears and Marie were building and managing, but not many images of the actual artworks. Vara protects artworks, not artists. So for each and every artwork, I testified to all three qualifications. So recognized stature as per an art expert, and that would be me. So I gave my own visual analysis, which is pretty much a very well trodden path that art historians use in terms of looking at art, in terms of quality, craftsmanship, effort, conditions. I interviewed artists. I leaned on oral history of the artists in terms of what they had to do to accomplish the works, and really discussed those kinds of visual significance of the work. The second was other members of the artistic community. In that, that was more about gathering documentation, and I had to use what is more of an emerging kind of process amongst art historians and looking at, kind of digital art history and looking at blogs and reviews, regional articles for every single artwork. And then the third was some cross-section of society, and probably some cross-section of society is the most expansive, and in my mind, probably the third piece where there's going to be lots of wiggle room and probably lots of discussion in upcoming cases about what is some cross-section of society. It just could be extremely expansive or limited. And for there, I looked at Mears and Marie provided thousands and thousands of pages of what we call primary research, including copies of emails of the thousands of people that visited 5Pointz and requested tours. We're talking art professors, tourists, art lovers. There was even corporations, workshops, and I kind of analyzed all that and summarized that. There was even people who did their wedding photographs at 5Pointz. So I gathered all that for each and every artwork. My testimony was about over 13 hours. I think it's about 1,000 pages. It was relentless and endless. And I'd like to say, besides my testimony, what was very, very crucial is the artists themselves testified to each and every artwork themselves, which was very, very difficult. You can imagine. It's pretty, even myself, who I'm in these environments more often, many artists don't want to stand on, in front of a judge. It can be pretty intimidating for everyone involved. So it was pretty incredible, and actually their voice and their testimony had a lot of weight, I believe.
Thank you, Renee. And then I think it's a perfect segue to Angelo, who was also an expert witness in the trial. Angelo, how were you selected as an expert? You're at Doyle, and what was it like being cross-examined, and what do you think you contributed?
It was fun. It was so much fun, right?
What do you think you contributed to the artist's case, and maybe you could just speak about some of those issues.
In 2012, Doyle, which is an auction house here in the city, we created the first auction in the U.S. devoted solely to street art. And I was the specialist for that, so I consigned all the paintings and cataloged them and valued them, and we auctioned them. And because of that being the first of its type, it was a self-fulfilling prophecy in that when one would do a Google search to find out where this type of art is being auctioned, how it's being valued, Doyle's name and my name kept popping up. So when this case was happening, the wrinkle is that when we're looking at valuation of art, dealers and gallerists are fairly opaque in that they can say they sold something for a certain amount, and maybe they did and maybe they didn't. But at auction, this is a very regulated system, and the results are publicized, and that's the nature of auctions. So it gives it a credibility, and unlike if I had owned my own gallery and simply sold graffiti art, I am working for a corporation that pays me a salary. So when we talk about the legal ramifications, the merit, and the recognized stature, well, okay, you have a New York-based auction house that has a global reach, auctioning the artwork, and that setting sort of a value almost in the way like a stock market would for, when you bring a new company to market, like that sets a precedent that's documented that other people can value from. People can do appraisals based on those precedent values, things like that. So
A market value.
exactly. So Renee reached out to me, and was lucky enough to be part of the trial, which was a fantastic experience.
I mean, many people in the average world, in the average community, they don't believe there's a marketplace. But the truth behind it all is Vara does not require an economic value to be around art. I mean, Vara is supposed to recognize, and that's why there are these kinds of 3 points, and you only have to satisfy one of the 3 points, is that it's economic value, social value, aesthetic value, cultural value, historical value. There's many different ways that,
Absolutely.
one could suggest that there is value, but having a marketplace and having someone speak to the fact that, yes, actually people buy these kinds of things and they collect these kinds of things and they collect these kinds of artists and these works are within those kinds of styles, was, very, very helpful.
I'd like to say also that the entire statute is geared towards recognizing moral rights of integrity and attribution. It is not exactly a copyright in and of itself, but rather the integrity means that they can't deface it, the work of art, and it's something that so it's more than just the legal rights that you typically see with a trademark or copyright matter.
These are the non-economic rights.
These are the non-economic rights, the effort that people put into it, the expression that they create when they make art. And these are moral rights that are recognized. And from what I gather, a lot of other countries have much stronger rights than we do.
That's absolutely correct. Moral rights are far more expansive in other countries, notably France, and which believes that the artist injects his or her spirit into the art in the process of creating art.
Well, I dissected I read the decision. I read a re-argument of the decision. And I dissected it, and I was thinking to myself, okay, if I had to argue this case, and by the way, I'm not involved, I'm not one of the attorneys on the case, so I have no restraint or compunction about commenting on it at all, even though you all may not want to. I'm happy to. And a couple of things that I discovered was that, first of all, the expert testimony is very helpful. And both of you were given very high marks. The expert on the other side was not given high marks. It's not required, but it's very helpful. So you don't have to automatically have an expert to win one of these cases, but it certainly helps. Second, the court is supposed to use its common sense. They don't want to, the standards in the law are somewhat murky because they don't want to limit the court in how to decide these cases, and when you talk about the recognized stature, the stature is generally taken to mean that the work of art itself has some merit, which is something that you guys speak to, not me, and also that it is recognized, and the recognition is sort of, it doesn't have to be recognized in journals or in magazines or anything like that. In fact, what I did is I analyzed the decision and I thought, well, what are the things that the judge in this case was looking for when he said it was recognized? And what I came up with is, first of all, you can infer recognition from the stature of the artist. That makes perfect sense. I mean, you know, you don't have to have a whole lot of things written about a work of art. If somebody brings a Picasso up from the basement, it's going to get recognized. And the second thing is they also made a very, the judge also considered how long-standing the work. So there was a category of works that were sort of given a higher status, that they were more or less permanent or long-standing, I think the word was. And so the judge considered that too. Three, he said he was interested in this community-based standard. And it was very interesting to me, because instead of him trying to say, okay, what's a community-based standard, he had a jury, which were members of the community. And just before the case went to the jury for a decision, the attorneys on both sides agreed that they would prefer to have the judge decide the case. But the judge kept the jury and didn't tell them. So the jury came out with, I forget how many, 38 works that there, or 41 works. So he used that too. He said, obviously, a community standard is represented by these, by this jury, and this jury found 41 of the works were, you know, of met a community-based standard. He also wanted to see whether there was any social media, whether there was any third-party attention. I was not aware that there were these many emails. I mean, it wasn't written up in the decision. And then he also considered, in this particular case, actually where the works were located, whether they were inside, whether they were outside, whether they faced the 7 train, whether they were on the tin, whatever building that was. There was one building that was tin. So these are the things the judge considered. Obviously, these factors are not something that will appear every time. My take from it is, don't try to limit yourself. When you have a work of art and it seems to have some recognition and it has merit, and that recognition can come just from the artist alone, that it may be entitled to protection. But it's not just that. It's also, you don't have to prove that it's a recognized statute. You also can just show that it prejudiced the artist or his or her reputation by destroying it. And that's something that you know, the judge went into a little bit too. So this judge took the Carter case, which gave somewhat of a map, and he expanded it greatly. The other takeaway I got from the case very strongly is, don't piss off a federal judge. Very bad idea. Very bad idea. And I'll also tell you, the fact that he was giving you guys a hard time, as we discussed in the other room, he was doing that because he wanted to create a record to show that he wasn't favoring, which, by the way, is what the landlord is now claiming, that the judge favored them. He liked the works of art. I looked at the works of art. I liked them too. That's not a reason to disqualify the judge. But he gave you a hard time because he wanted to show that he wasn't favoring you. So.
If I can add one thing, also the judge put a lot of weight. I spent a lot of time in my testimony, and you can speak to this too, talking about Mears was not just the artist, but he really was the curator. Now, as a curator, whether, you know, that grew up organically, he became recognized throughout the world as someone who had an eye and an understanding of the quality, the craft, what artists, and he, you know, actively selected the works. Now, maybe it's not the Whitney, but he did go through a selection process, and maybe Mears, you can speak a little bit about that. But, you know, he recognized Mears as other members of the artistic community, which both I spoke to, I think you might have spoke to, and then Mears himself testified to his curatorial kind of imprimatur that he brought to the table for over a decade.
Well, this is a perfect opportunity, Mears, what your role was as a curator, and how did 5Pointz develop into the artistic hub that it became?
Organically.
Okay.
And lots of work.
Yeah, I started doing graffiti in '87 and did it for the most part illegally wherever I could. we had opportunities to paint legally, we took it too, but it wasn't that present. In 2002, the idea to start a place that would be a legal outlet for artists to come and kind of showcase their skills, whether you were amazing or you were a potential beginner that just wanted to dabble. We offered space, and like I said, I didn't go into it with any expectations other than that. And as time went on, I started to realize prime real estate brought in the lure to more talented artists to create by giving longer running, spots that artists would, put in more effort, and the competitive nature of the art itself brought the bar up, and it just continued to bring the bar up, including all the other elements of hip hop, which we did have there present too, brought in a larger audience, and we inevitably do what we do for an audience. So it just slowly brought itself to the high level it was. And I mean, I've done lettering as well as, I do every kind of art, photoreal, cartoony. So it gave me the respect amongst the artists to be able to make those decisions and them to honor them. And it grew.
And also to be a caretaker. When a space which was 200,000 square feet is covered with art, having an artist and an experience acknowledge and recognize artist was also, as a curator, enabling him to care for the art. And if a wall was damaged, if a truck hit a character photoreal, Mears was able to fix that face if the artist was back in London or New Zealand. So it was welcoming the artists, giving them obviously suitable location for what they were going to create, push them to always do better, and also care for the art till the end, till the last day, protecting and caring for the art.
Marie, how did you become? And you were the spokesperson for 5Pointz, and how did you fall into that role?
Pretty much, organically.
Yeah, right.
I'm being French, I have a tendency to like to speak. So I met Mears in 2005. Started going to 5Pointz regularly in 2008. And in 2009, he asked me, again, this was a very organic, non-funded organization, and he asked me if I would help and kind of jump in and help organize a little bit. I have a background in marketing and event planning, so I kind of took on a lot of all the events which were occurring and happening at 5Pointz, where 5Pointz was also a stage for every element of hip-hop. And by doing so, I started dealing with a precinct to let them know what we were doing. I was talking to neighbors. I was also a resident of Long Island City. So I was hearing a lot of what the community felt and how they felt about 5Pointz and PS1 across the street. So it happened kind of like naturally and organically.
In your own words, what is the case about? What is it about? What is it not about?
Well, what the case was about when the artist filed for injunction was a desperate attempt to preserve art that cannot be reproduced, that's lost forever. And you were touching on not just stature, but an artist's honor being hurt under moral rights. I mean, I'm sure a lot of you have your cell phone and you have Wi-Fi. If you were to Google right now 5Pointz image, you will see whitewash pictures before you see the legacy and what you're seeing on the screen. So the case was about trying to prevent this. The case was about artists getting together, learning about an obscure law, and seeing a hope of being able to remove, photograph, document, store, and make this last collection standing on 5Pointz, not gone forever. That's what the case was about. By the landlord whitewashing the case, now the case has become about the consequences of not following federal law and not giving 90 days notice to artists to be able to document or preserve their artwork at their own expense. And since the building was going to be torn down, there was no any type of damages for this landlord. I mean, he could have very easily sent a letter, give us 90 days, whatever we would have saved, we would have saved. But we would have pieces, we would have relics, we would have better documenting, drone footage, and we don't have any of it. So the case was about standing up for the art, certainly not about monetary damages. That came because of the action of the landlord.
Do you
If I could
perceive
interject, just
Yeah,
there's
go
another
please.
piece
Yeah.
to this.
Yes.
Is the value of the space itself residually within the community. So if you look at Long Island City, when 5Pointz was there and thriving, there really wasn't a lot of other reasons to go there socially. PS1 obviously, but really, and so when I was testifying, I was really concerned about having the jurors tune out by getting too into the weeds with art history. And I touched on a few things here and there, talking about Lady Pink and an artist like Zmad, who had a few pieces, and different peer artists that people may know, or artists they looked at, or artist movements like surrealism, or whatever the case may be. But really, I wanted to make the point that 5Pointz had a similar value as the Apollo Theater, in that it was a community space, and it. If one goes to Apollo Theater, you're probably going to have dinner somewhere within the next few blocks. And the same was true with 5Pointz. And that allowed the value of the property to go up. People wanted to live there. Restaurants needed to open, bars needed to open to, help facilitate giving the community more to do as more people came to visit the space.
And when Mears took over the space for New Yorkers in the room in 2002, you didn't want to walk down Davis or Crane Street past 4 o'clock. You had drugs, you had prostitution, you had crime. So 5Pointz also kind of became this kind of gateway to a safe creative heaven, and also made a block and a part of Long Island City that certainly was not attractive, welcoming for families, welcoming for artists to express themselves, welcoming for schools that do not always have budget to do workshop and activities. It was for everyone.
Do you perceive a chilling effect as a result of 5Pointz, that artists, that landlords might be more reticent about allowing artists to paint on their walls?
We haven't felt it. And I'm sure that's also a legal aspect to that question, but Mears is a full-time working artist. A lot of the artists in the case are full-time working artists. In no point have we felt or are we being told, we don't want to work with you, or we're not going to give you a wall, what's going to happen? It's actually the opposite. It's important to understand that Vara applied in this case because all these murals were self-expression. They were not job for hire. Job for hire are not protected under Vara. So for a lot of landlords in New York that love benefiting from street art, the easy way is hire the artists and pay them, and then you're good. But
or you could have them sign a Vara waiver.
I wouldn't, as an artist. I would definitely not recommend for any artist to sign their rights away. But I think it
not their
doesn't
copyright, but their Vara rights.
Yeah.
It's something.
Yeah, but if you're looking at the law and how it was broken down,
right.
If you give your rights away and your wall is damaged, and you want to fix it, and the landlord changed his mind, or he's no longer in the property, or he doesn't care, or he paints it poorly, your art is going to be poorly represented for the world to see. Which is the biggest example is obviously the whitewash of 5Pointz. So I feel we have done a lot of projects for hire and not for hire. It's based about communication. Lawyers are going to say more papers, more contract, more billable hours. I feel there are a lot of great collaboration between real estate and artists in general, not just graffiti or street artists. And it's based on dialogue and self-respect and a common vision. Now, maybe a backsplash could and has been miscommunication, misrepresentation of the case in the press, just the fact that it's never pointed. All this artwork was done legally, was sanctioned, and was not for hire. The artist donated their time, talent, craft, supplies, including Mears for 11 years.
So if I can comment
Sure.
and on my perspective. So I work in the private sector a lot. And in the private sector with artworks that are even conserved, there is potentially a loss in value after a work is damage, and then it's conserved, and insurance companies get involved and pay those settlements. I'm involved in that, in some mediation issues and valuation issues. I also field a lot of calls from artists now who call me directly. And I would say two things. One, it's really quite interesting to watch the business community and the insurance community actually to really say, you know what, you need to call the artist before we decide on conservation. If the artist says it's good and the owner, the collector of the work, doesn't like it, well, you know what? The artist's rights might prevail. And I'm seeing that a lot. And there's no litigation. It's a discussion that is happening amongst the people involved, conservators and appraisers and advisors and insurance brokers. The second thing with artists is, interesting enough, I'm actually seeing a bit of like what they call trademark trolls. I hate to say this, but trademark trolls are these lawyers who kind of like run around and create a lot of fear and tell everybody, and all they do is like create this like kind of nuisance like complaints against trademark. And so I'm seeing a bit of fear being put in the system. And I would just say for artists, like, this is not a light undertaking. I've seen many cases in the last 2 years settle, not going to court, and the artist, doesn't want to, give up. But sometimes the settlement would be much better when you look at the long-term perspective. Some works have been preserved, some works have been relocated, bought. Artists need to go slowly, but who I see running the fastest and I feel like is overreaching is some of these attorneys who don't work in the art law space and are creating a lot of fear. So that's my perspective.
And for artists, if you're going to enter in any litigation, it is important to stand up for your art and for your rights, obviously. But make no mistake, this is not an easy process. I mean, you're going to hear from different experts. I mean, even the amount of hours Renee worked on this case, but for us, it has been our life for over 5 years, and it doesn't stop. So, and for artists to have to testify and relive, and imagine looking at your artwork, whitewashed, destroyed in federal court, and then have to stand up for yourself and justify who you are and your merit as an artist. It's not easy, so let's not all jump and start suing each other and everybody. I think communication, dialogue, being informed, knowing who you're entering a partnership with, and keeping a clear sight or idea of what it is you want. The first thing is work with people you like and you respect, and get to know them. Do your homework.
I mean, the artists have no other recourse. We haven't mentioned, but we had a conservator talk about, because most people are like, well, how are you going to remove that? You can't remove that. But actually, her name is Harriet Ergang Alden, sorry. Mm-hmm. And she testified to the removability. Some of these works could have easily been peeled off. They could have been skimmed off. Some were on windows, some were on pieces, on siding. There was all kinds of things. I've seen Basquiat's removed by conservators on concrete walls. You can cut them out. I've seen a Keith Haring. So there's all other kinds of recourses that maybe been pursued, but these artists in this case, they had no other route but to pursue the legal route.
One of the interesting things to me about the case was that the judge initially refused to grant an injunction. And I understand why the judge did that.
It was early on in the case.
What's that?
It was early on in the
yeah,
case.
and the reason for that is that in order to get a preliminary injunction, which is what was sought, you have to prove that there's a likelihood of success on the merits, a balancing of equities, and irreparable injury. There had been no case law on whether or not these ephemeral, temporary works of street art would actually be covered. And
the judge also thought that that they would be protected under their copyrights as well, and they would be able to receive.
And so the judge backed off, but he made it clear that I'm not granting this injunction now. The other thing was that which came out in a subsequent decision, is that the property owner was not truthful with the court, and told the court that if they didn't destroy the building immediately, that they would lose 421A tax benefits, and it would cost immeasurable amounts of money. that turned out to be untrue. And when the judge found out about that, like I said earlier, you don't want to piss off a federal judge. So what happened here was there was a preliminary decision. The judge gave a verbal off the bench and said he was going to write a decision. In that short 8-day period, they whitewashed the building. The judge warned the owner of the property that, you know, it could be that even though I'm not granting this injunction, it's because you didn't meet the standards for the injunction, not because I believe the case is bad. It's just too early in the case to make that decision. And he warned the property owner that if you whitewash, and I find that there is, has stature, recognized stature, it's going to be big and bad. And this guy didn't care. He was remorseless. He thumbed he thumbed his nose at the judge, and he got nailed. And to me, I mean, it was a front page of the Law Journal case. It was a shot across the bow. I was interested in it because I represent a lot of tenants in buyouts, and I have to put myself into the head of the property owner. And I thought, this is another tool in my toolbox. Mm-hmm. You know, it's something that I will be able to use to protect these people, either to remain or at least to get paid if they have to go and can't keep the art.
Well, I know we could continue for a long time, but I'm wondering whether there may be questions in the audience, and this would be a time to turn to some questions. And please wait for the mic.
When you're valuing the art on the wall, what is it you're valuing? You talked a little bit about the possibility of removing some of the stuff. What is it that's sold?
I think that was really the problem with the testimony that I gave, was that the defense attorney was willfully ignoring, but in my opinion, what the intent of the artists were. And so he was hammering me on a lot of things about a very literal sense of removing things from a wall and then selling them and this and that. And, you know, that's not really the value. With the thing with street art, with art that's made in a public space, is that, you know, these are artists. Mir has artwork that you can buy. You can go and purchase something from him, and you can own that in your home. And by paying him, you're supporting him. But there are people who create a black market and remove things from public areas, and they sell it without the artist's permission. It's not necessarily stealing, but it's frowned upon. And anytime you go to sell something of an artist's without their permission, without their sanction, it's a bad thing. There's problems there with authenticity, with any kind of verification, any kind of studio approval. All those things are a problem down the road. So when you later on want to donate it or insure it or whatever the case may be, or resell it, all these problems are going to come back. That was misunderstood, and they were driving this point of the literal object. And for me, at least, the value was in the space itself, what it provided the community, and all the different things people could take away from visiting.
I was just thinking of what kind of advice the owner might have gotten. What is the judge going to say if I whitewash it? What did I whitewash?
Well, I mean, oddly, he testified quite consistently that he loved the works. And, you know, if we talk about value, we know many communities like Soho, in fact, was gentrified off of the backs of artists, as was Williamsburg. And this is a formula that continues to repeat itself. And, I mean, if you want to talk about value of art, I mean, he has named the new development site after 5 Pointz. So talk about value, $450 million. So maybe the artist got shortchanged. I don't know. But we talk about brand value and community value, and, here, he's like kind of tit for tatting these things. But it doesn't really matter because Vara doesn't worry. I mean, Vara is not focused on economic property value. Right?
Not only that, but the statutory damages they got are specifically not related to the value of the work of art.
Absolutely.
They are separate. So there's two ways you can get the value of the work of art, or, which is very difficult to prove under all these circumstances,
Right, exactly.
or the statutory damages, which are multiplied if there's willfulness. So that's some of the things that I saw also in the case.
Absolutely. Perhaps there are other questions in the audience? Anybody else? Yes. One second. Sorry.
I didn't catch your name, but the gentleman at the end of the day.
I'm Steve Wagner.
Steve Wagner. So you mentioned how the preliminary injunction didn't go through because there wasn't enough case law. I'm a current law school student, and so I was wondering if you could talk more about the importance of like the precedents there and what that means for your future clients or artists in general.
Oh, yeah, sure. The case is on appeal, so subject to the appeal, and I'll tell you, I've read the summary of the arguments of both sides, and I told Mir that I like his side a lot better. But that aside, this case is kind of a landmark case. This and the Carter case that we were talking about earlier are the two cases which are decided. These cases are very expensive to bring, and they take a lot of time and energy out of people's lives. A federal trial, a 3-week federal trial, is no fun, and so it's not so much that you're going to have this repeated over and over and over again with more and more decisions. This case set up the path, and people are not going to want to spend the money. So it'll become the guide for how you deal with these problems in the future. And in that respect, I think it's very important.
And in
Very
fact, there are very few Vara cases that have been
Right.
ruled upon. Very, very few. A handful, perhaps.
Yeah, and this
around
one's
the
front
country.
page of the Law Journal, $150,000 per artwork for 44 works of art. That's big stuff.
I also want to speak to, artistic community, although and Mears, it'd be great for you to speak to this issue as well, is that, from what I understand from 5 Pointz is that Mears and his community and his colleagues, and they were building a monument to show generationally and stylistically what street art or what graffiti or aerosol art was. They were trying to define it and show the best and really create that kind of a museum to it. But the case itself, and it wasn't a collective action against art history or against institutional art or anything of that sort. However, the case itself and the artists coming together and collectively working and actually winning as a community is actually quite significant and unique in American legal history, because there's only kind of one other I was speaking to a few other attorneys. There's only one other major case, and that's the Soho Loft law, where artists actually, artists are often individually focused and they're isolated in their own, and they can be. Some of them are narcissistic, and it's all about them. But this was a very unique situation where they created a collective action in terms of unifying around a cause. So I think that's probably
huge
pretty
legacy. Yeah.
significant.
Yeah.
Any other, Akila?
Go ahead, Mears. Go ahead.
I was just going to say the graffiti itself is a very ego-driven sport, and a lot of times artists are really consumed with themselves and their own well-being. And I think 5 Pointz in bringing the community aspect and having the top-tier writers interact with the beginners and everyone started to respect each other and respect art, and it was like a learning tool for everyday people that see murals every day in walking and don't get to take 2 minutes to talk to an artist or watch their process or ask them why they're painting. And I think the artists started to believe in the value of the art that we all love, and the importance of it, and we did gauge that was a graffiti museum. It wasn't, it was a museum, and we did it without funding. And we got more people in PS1, and I know it's off the record, but it's the truth.
Really?
Their booze parties were really, popular, but in terms of this, the hallways being full, not really. And I went in there numerous times, and we did it with no funding,
Perhaps you could tell us about this. The 5Pointz creates the new MoSA, the Museum of Street Art, and what your projects are now.
Well, I think when the building itself was destroyed, it didn't destroy the movement, and I think it was important that we showed that as an organized movement, we are still around and relevant. And we've done several projects. We went into August Martin High School, which was looked at as one of the worst high schools, graduation rate, and Marie in organizing, and I pulled together about 150 artists from all over the city.
In 2 weekends.
And we painted the entire school out of our pocket, and it was a change.
It was a wish of the students wrote us a letter, and they were like, "We're in Queens, and we have the worst reputation, and our school looks like a jail, and you just lost your home, so do you want to move in?" And that's pretty much how it happened. And every single artist Mir School said yes.
Everyone, and the best of the best
And we're lucky because it was June, which is it's high season for painting in New York, which means we had artists from France, from Japan, from Israel, so for the kids to even have artists, international known artists, that was definitely a great project.
And on a
right
personal
after.
note, I was very stoked because we were able to do our lettering, the wild style, everything that we love, and not be kind of filtered, like you can't do this, more street, So
and
that
lift
was
everyone's spirit in the meantime.
it was
It
great
was a
for
reunion.
us.
Yeah, it
It
was
was
the first
great.
time we had so many artists in a place
Yeah.
since the end of 5Pointz. I think the biggest event was 40 years of hip hop, and that was August 2013. And we had Cool Herc and Marley Marl, and there is actually one of our musical fam member over there, Rabbi Darkside, aka Sam Seller, who's a professor at New School and a hip hop expert. He gave the last universal prayer at 5Pointz before the weekend, before the whitewash. And we're together also with all the elements. So MoSA is our most recent project, which is a museum of street art within Citizen M Hotel at 189 Bowery. One of our biggest fear sometimes, I think, as collective of artists, is for the art to become a marketing tool. Graph and street art is very trendy right now, from Louis Vuitton to. So it was a fear, and to find a Dutch-based company who asked us to collaborate, let us pick the canvas, which is 21 floor, it's a staircase, and then agree to carry the burden of the cost of having it open to the public for free, 7 days a week, self-guided tour. I've given over 1,500 tours at this point since October 1st, and we are now able to also bring the musical elements and kind of, we hope that's the legacy. It's kind of, to not give up. The collection, the permanent collection of 5Pointz, it's lost, it's gone. Unfortunately, photography does not do it justice, but at least we can now maybe use that exposure and what happened to 5Pointz to keep this organization and keep the artists creating together and bring newer generation of artists. Our youngest artist at MoSA is 25. He only painted at 5Pointz for 1 year in 2013, and he's in a collection with Lady Pink. That's what 5Pointz was about. It's egalitarian, and it's kind of teaching and showcasing where the art form is. So follow us on Instagram, and you'll see what we're up to.
Akila, you had a question, yes.
So it's actually related to what you were saying earlier, Mir, which segues perfectly. So this question is for you. And I understand like the legal and economic ramifications surrounding this case, but I'm more interested in the cultural aspect of it. So my association with graffiti, aerosol art, street art, whatever you want to call it, has always been that it's of the community, and that's where the communication stays. And for so the interpretation of it was always privileged. So if you wanted to know what the meaning was, you either had to approach the artist or you had to be there while he or she was creating it.
Yes.
But now with this case, you've had artists who have had to go on a stand and explain it to an audience that maybe I'm being negative about this, but many of which still criminalize it, or they don't truly understand like the history of it or the cultural value or the community value of it. So I'm wondering, yes, there are very many positive things that can be attributed to this case, but do you feel, is there a possibility that this can in fact damage the reputation of graffiti and preserving the purity of it?
Well, I think a big part of fear is not knowing, and people automatically will associate whatever they want to think about it without. So that's why I don't feel us going and testifying to judge, and is going to hurt it. It actually was interesting to see a 80-something-year-old judge who I would never in a million years would have took the time to listen to us, since my own father doesn't really particularly care for graffiti, and he's not that old. It's ever evolving and ever changing, and I think it's important for us to kind of change our perspective and our thoughts. I do it for the same reasons, and I believe in the art form for the same reasons, but it's an important tool, it's an educational tool. We can use this art form to teach other things. I think you have to evolve and adapt, and I don't think it's destroying it. Some artists in my own culture were like, you fighting, you're destroying. Some artists.
I actually think that was one of the strengths, one of our strongest strengths, was that many people do bring a stereotype of graffiti artists and that mindset, and certainly the defense tried to use that very strategically. But the artists showing up and showing how professional they were and how responsible. I mean, it's quite incredible to think of all these thousands of people, all these parties they had with like Red Bull and Bebop. I mean, they never had one arrest there in over 10 years. Can you imagine? This is not like PS1 or MoMA where they have, security guards. Like, how did you do that, Mears? So I think that actually,
we walked around the block
the artists and showing up and being respectful of the judge and answering the questions, and they kind of just blasted that stereotype, like they just blew it up. It was awesome, quite frankly.
If I may, I think your question was kind of like graffiti, you had to be in the know. You could read it. That's your point. So are we kind of killing the spirit or the roots or the essence? And I think that would be a great question for Lady Pink, because trust me, she doesn't want to go down in tunnels. She doesn't want to do trains. She's happy being a successful gallery artist. She has paid her dues. And it's an ever-changing, ever-evolving art form, from the tools to the craft to the aesthetic. And in no way the fact of standing up for legal representation of an art form birthed in New York and Philly and started, yes, as a secret society, as a voice of anger, of an affirmation of existing. It's not compromising what it is today, because thankfully today in 2019, 21 graffiti artists, some that have started painting in the 70s, were able to be in court and stand up for their art. And it does not in any way challenge their intent, their career, the truthfulness of what they do when they pick up a spray can. They just are older and tired and don't want to bomb.
And slower.
That's pretty much it.
But even an artist mature in their career, or a band that starts as a garage band and becomes like an international, like everybody struggles with this. When they kind of maybe go from an insider game to something that's a little bit. I mean, I think contemporary art's struggling with that now. Contemporary art's gone mass culture. So we're all looking at that. So it seems like it's a kind of natural progression.
Well,
I- the
thank you
ju-
for
I think
that,
there is
and I
one.
think, okay.
Poor guy, he's being
okay,
like,
okay. I do want to leave time for a glass of wine to toast this, but yes, please.
I'm just curious, how is it determined which, I guess, works were worthy of further consideration, as well as which specific artists would be involved in the case and receive part of the settlement?
It was a very short window of time, and at the time when we were kind of formulating how it was going to happen, it was the artists that were there, that were
And
willing to
willing.
step up, that we knew. We asked, some artists didn't want them. Some artists didn't believe in it, some artists,
we're afraid.
were afraid,
Didn't want to
and
go to court.
it's whoever stepped up. It could have
But-
been everyone, it could have been less.
But based on quality of artwork, obviously having Lady Pink, you never know with her how she's going to react. But to us, it was important. It was one of the oldest pieces on the building. She's obviously the godmother, and pretty much that's how it was. But no matter what the answer of the artists were, no hard feeling. It's obviously we're not going to name. Everybody, they all deserve their privacy and how the process was. But it was an open forum within the family of 5Pointz, and people considered everything. And trust me, had we known, over 5 years, I think if we were to go back in time, as worse as the fight is, I think for a lot of artists, no one knew it was going to be so difficult and long and tiring.
And an
And for-
invasion of our privacy
Yeah,
and
and
everything.
huge invasion. There are a lot of, and as far as you answer on the financial rewards, it is the rewards given by the judge as of now, which is an appeal, is per piece of art. So the author gets the amount, and then if it's a production, collaboration between artists, then it's separated in between the artists who contributed to the wall.
And this was for the bigger murals as opposed to smaller tags or throw-ups?
Tags and throw-ups were not in the case.
You can see the quality
Yeah.
of what was testified. I mean, the fact that they didn't do a tag or throw up was helpful because you could just talk about the hierarchy there, and it was a lot easier.
But again, don't forget, the goal was to preserve and document the art. So these 45 pieces in injunction and presented were ultimately, hopefully for us, going to buy us time to figure out how to remove what could have been removed to document. Don't forget, 2013 was never about damages and where we are today.
And I think
Was
that was
never
a,
the intent.
I think that was a strong part of the case, is that in invading our privacy, there was no evidence of that.
Yeah.
It was solely to save the art.
There's a question over there, and one last question.
So you mentioned that it's a good idea to have a good relationship with the person that is allowing you to have that canvas. And were there multiple artists? Were you, Jonathan, in contact with the real estate owner? Who was, and where did that miscommunication happen? Where you guys felt that you were building this museum, and he still all along felt that he was eventually going to tear down the building and destroy it.
If you're talking about the landlord of 5Pointz, our relationship was very minimal. I pretty much dealt with the mostly with the on-site super. He was the go-to, and I've had less than 6, I think, meetings with him in 12 years. And rumors are rumors. I've heard from day one. But if you saw Long Island City from day one, you would never have thought that Long Island City would grow to be what it did. I didn't have an idea of anything, so everything unfolded kind of organically. I thought realistically the whole project would have been done in 2009 when the exterior staircase fell, and the young lady fell, I think, 5 floors and nearly died and eventually passed away. I thought it would have been over then, and we were asked to come back. So I kind of rolled with it, That would have been a clear-cut exit.
I don't think there was miscommunication. There was no
No
communication.
communication.
And also, depending on who you partner with, be assured that if we had broken any rule, or if Mears had not kept his end of the deal, which was to have this place safe, to make sure that there were no political content, religious content, pornographic content in respect for the community. Had he done anything wrong, he would have heard from the landlord. But as a curator, as a person in charge, as a person entrusted, he exceeded every promises and every commitment he took upon with the landlord, but also for the culture. And to think after 11 years of peace in a building, a phone call saying, hey, guys, I'm going to apply. No, it was newspaper article, a clip here. And there's a beautiful thing, it's called the Department of Building. You look up a bin and you see if there is a permit being asked or apply or filed for demolition. And it wasn't the case. So you can't constantly live in fear and be like, oh my God, this is going to happen, because it wasn't. And we felt, because the organization as it grew kept on keeping its end of the bargain and being respectful and doing everything asked and more, we felt the same kind of maybe respect and communication would have been extended. Not they knew, not after 11 or 12 years.
I mean, the landlord did give explicit and implicit permission. And if you look at images on the roll gates, is like, do not trespass, contact Mears with his email, so it was very clear he was the go-to, he was the gatekeeper, and that was permitted. And a permission piece is important. So, somewhere it went awry, but that didn't necessitate whitewashing.
One of the things that the judge mentioned in a motion to re-argue, go to your point about culturally, is I think it was maybe even questioned you about, they questioned the landlord about whether anybody had ever broken any law, anybody had ever done anything that they didn't want them to do, that in any way violated any of the agreements they made. And he was, no, they didn't. And he was the guy who whitewashed the place. I mean, you could see where it was going from the questions that the judge was asking, but he put it in. The judge had the courage, I guess, at 80 years old, to just say, "I'm letting it all hang out. I'm putting it in the decision." This guy was the bad guy,
and it was several
These people
times.
were not.
It was whitewashed over several days, not just one.
And not to belabor the point, but I don't think it can be overstated. These decisions were made by someone with the intent of having a marketing program using everything these people built. I mean, the lobby is supposed to have photos of graffiti art in it. The building is called 5Pointz. So to say this art has no value and then base a multi-million-dollar building's marketing campaign around what you're saying has no value makes no sense.
It's ridiculous. And I think the judge saw that and saw the value of the art and the value and the integrity of the people. That's what I got from the decisions.
And now, okay, well, I think that, well, thank you very much for all this. I think